Good afternoon. My name is Wesley St. Clair. I'm the Chief Judge over at Juvenile Court, King County Superior Court. I want to welcome you to, glad to see all of you here to join us in the conversation that we are engaging in on issues of restorative practices. So I've been doing restorative practices in our court. I was first introduced to it as when I was appointed Chief Judge at Juvenile Court. We're building this new building, and it's really a point of dissension, hot topic in our community. And so I thought it was part of my job, needed to reach out into the community to figure out where are there actually points of commonality. And part of that conversation actually resulted in us finding out that we have more in common about trying to create safe, healthy families and youth than we have about a building. So my conversation is not about a building, but about a system. Because the reality is our juvenile justice system actually manifests some of the ills of our community as a whole. We have the crises that is occurring with law enforcement and the community of color. We have implicit bias. We have institutional racism that is not being addressed. And so part of the conversation led me to what can we actually do? And in the course of talking to the community, they said, Judge, what about restorative justice? And I go, what? Because I was not that familiar with it at that point in time. And so I started doing my due diligence to figure out what is restorative justice. But really, my conversation is about what are restorative principles. Because justice talks about courts and law enforcement. And the issues that face our community are more than just courts and law enforcement. It's schools, it's behavioral health, it's mental health, it's housing, it's financial institutions. Every aspect of our community is dealing with an inability to address the topic of institutional racism. So my belief became that this restorative, I actually started doing peacemaking circles. Oh my gosh. I can't believe I'm doing this. And I was a very reluctant participant in that model. It took months for them to convince me, and I always had conflicts on my calendar. Oh, I can't do that. Well, once I start doing it, and I've been doing it for almost 2 years at this point in time, it really sets up opportunities to establish new relationships, new behaviors. And if we kind of understand each other at a different level, then there are new opportunities, new horizons that present themselves. And maybe we will generate the opportunity to talk about one of the most difficult conversations that we have in our country and probably in the world. And I'm finding out in the world from my New Zealand buddies that they face the same types of issues that we face. And they'll tell you about that. But I think this restorative practices can be a way for us to have a conversation about race in a fashion that helps us become healthy and grow and mature and do better. So I'm excited that these guys are here. I'm excited that the court has engaged. Yesterday we began an experiment around 10 months ago. And with the help of the collaboration of a wide variety of people, starting off with the King County Prosecutor's Office, the Office of Public Defense, the Probation, Department of Adult and Juvenile Detention, Pam Jones. I could call out a lot of names, the Executive's Office and Dave Chapman, Marcus Stubblefield. We began a new era in King County. And in the course of that era has been the result, part of it was yesterday, where we had over 200 community members come to Youth Services Center and cheer the fact that, and actually demand the fact that we do better. as we watched a young man who was facing very serious charges, resulting in 2.5 years in juvenile prison, resulting in him staying in our community and him maturing and becoming a viable, contributing member of our community. That's what we have to be about. So what we see happening in New Zealand gives us great hope. I've talked to these gentlemen and their support system that they brought with them, and I'm so excited about what's possible. Not easy, but possible if we have the courage to step forward and not be locked into the past of we don't do business this way. There's lots of possibility. There's such a great future for us. We really can lead the country in the process of redefining what our, not just juvenile justice, but what our justice system looks like. Criminal justice reform is at our fingertips. My question is, are we going to step forward and do it? Well, I hear one yes, but I got to hear a lot. And last night, I had the community saying, demanding that we do it. So this is very exciting. And so I'm going to hand it over to Judge Beecraft, the Children's Commissioner of New Zealand, and let him go forward. Thank you so much.
Ina mana, ina reo, ina rangatira, ina hauewha, tēnā koutou katoa. In the words of the Māori language of New Zealand, which is an official language, I acknowledge you all. The place that we're here today, those who have gone before, those who are here today, greet you all from the four winds and bring you threefold greetings from Aotearoa, New Zealand. I was for 15 years before this role, Chief Youth Court Judge of New Zealand, so Judge St Clair and I are sort of counterparts. We've had a great time the last couple of days talking about a new vision, a new way of doing things. I also live on the earthquake rim of the South Pacific. Now, Paulie, I've got to say, we have it drilled into us in Wellington, New Zealand, where we have a lot of earthquakes. The earthquake advertisement is drop, cover, hold under your chairs, and we learned that from absolute kindergarten onwards. I want to start this morning with a quiz. I want to put you on the spot. Here's an exam, all right? See how you go with it. The question is, what do these numbers mean? Some of you from New Zealand, and there are some who have worked here in New Zealand, it's terrific to see you, will know what those answers, know what those questions mean. Does anyone have a guess at what those numbers might mean? Any of them? Sheep. Sheep. You're right. 44 million sheep in New Zealand. 4.6 million people. And as Children's Commissioner of New Zealand, I've had the role for 3 months. It's 24% of the population. So that's my role as an advocate now for that age group. That many lawyers, which may or may not be a good thing, depending on your perspective. And this is the really important one for those of you who follow your sport. And that's us, just a snapshot of Aotearoa, New Zealand. If you're in any doubt where we are, that's where we are. We left Auckland International Airport at 8 o'clock on Sunday night and got to Vancouver at 1 o'clock Sunday afternoon, so we had the rare experience of arriving before we left. And with those words of greetings, and I am here with Judge Taumanu, who's one of our leading district and youth court judges, who's Māori and is a real leader in New Zealand, and Thomas Hohaia, who's a 14-year practitioner with family group conferencing. I just want to set the scene to give an overview, and then they'll come in and provide the real expertise. But just to start with, why are we here talking about youth justice? Why is youth justice so important? That's why it's so important. That is known as the age crime bell curve that is true in all Western communities, any time, any place. Offending peaks at 17 3/4 years. If we get right the 4 years each side of that, that's about 60% of offending. It's a pivotal and crucial time. It is crucial that we do better with youth justice. Youth justice really provides the template for a new way of doing justice. We've got to get this age right. So often it's an add-on and a tack-on, sort of a cut-down adult system. Our plea is, and we've been speaking to Judge St Clair, and his vision is a separate, youth-specific approach. Can I start by telling you a story in a youth court in South Auckland, tough area, and this young boy took off his hoodie, his sweatshirt, and he had underneath it a T-shirt. His lawyer bought me a second copy from the flea market, we call it. And this is what the T-shirt said, and I walked down the aisle and model it for you. I've got to say he had a lot better chest than I did. He was a big strapping boy. This is what the T-shirt said, if you can read it. Only the Lord, or let the Lord judge the criminal. Now that was quite an opening statement, because he just stood there looking at me, really encouraged and enthusiastic. And we've got a law in New Zealand that says we've got to encourage participation, get young people participating. So somewhat hesitantly I said, that's an interesting T-shirt. And he smiled and said, all good, boss. Then I said, well, it's a bit early to call yourself a criminal. You haven't even admitted the charge yet, let alone been in the court before. And he just smiled. But his lawyer was getting a bit concerned and was waving and saying, look, he's just urging me to shut up. But I persevered and said, well, I can't fault your theology. Then I thought, well, he probably doesn't know what theology meant. But he said, I do. It's about what we know about God. And I said, well, I firmly believe on the other side of heaven, on the other side of death, there will be perfect justice. But I said, the bad news is today in the Manukau Youth Court, you're stuck with me, Judge Beecroft. And he looked at me and he smiled and nodded all disrespectfully, said, well, I hope you get it right. Now that is a challenge for all of us working in youth justice. That could be the strapline for what we're talking about. Are we getting it right? What does getting it right look like? So just in the 15 minutes or so I've got, I want to talk about the bad old days in New Zealand. That's in the 1980s and earlier. 6 or 7 things that we did in youth justice that now we look back on and are pretty ashamed of, and we would never go back to those days. Not that we're in a perfect world now, but we've made some significant developments. I want to talk about that new paradigm. Briefly talk about family group conferences, and it was inspiring last night to be at the King County Juvenile Court and hear about the result of a circle process, circle sentencing, restorative justice, and to hear the community give sustained applause. And the women around me said, when Wesley, Judge St Clair, was speaking, one of them muttered, preach it. I mean, it was like a church. I mean, she said, that is what we want. One step from the justice system normally gets 100 steps back from the community. We cannot have justice locked up by the professionals in a court, because it's a community-based principle and a community-based process, and that's got to be something I think we should aim for. And just some concluding comments. So that's where we're heading. What do I mean by the bad old days in New Zealand? Well, this was us. This was the justice system for young people that was just so universally condemned as ineffective and failing. And youth offending is usually really easy to detect. It's done in public, spontaneously, often under the influence of alcohol, poorly planned with peer influence. I mean, it's called low-hanging fruit in New Zealand. It's easy for the police. And then the 1980s principle was, well, if it moves, arrest it. Charge all young people. Bring them to court. Often adult court. 14 or 15-year-olds. Let the experts make the decisions. They're trained, they've got the degrees, they've got the experience. And I speak as a judge myself, but the assumption was that wise judges always know best. Well, maybe Judge St Clair always does, but in New Zealand, I don't know that we got it right very often. We didn't have the good community-based information. And we always imposed a conviction. Saddled a young person for life with maybe receiving some Remember one famous New Zealander's got 2 minor convictions for receiving some frozen meat, stolen meat, when he was 15. He's got to declare it every time he travels overseas. And he's now in his 60s. High rates of institutionalisation, often really to address what were abuse and neglect and care needs. We were criminalising a cohort of young people who were abused and neglected and who had offended to a minor degree, but the underlying issue was child protection, abuse and neglect. We kept victims very much to the edge of things. Their voice was very limited, if at all. And it was a system that was monocultural. It was failing. And it was particularly criticised by our Māori New Zealand community, which make up 20% of the population. So it's a significant, well-resourced and thriving part of New Zealand. And they were absolutely adamant that things had to change. And things did change, mainly because of that strong Māori undercurrent, but also a belief in the community that whatever we were doing, it wasn't working and surely we could do better. And there was an appetite for change, to try things. So there was a vision, as it were, to involve the community, to involve families, to involve victims, and to have a culturally appropriate process. And it happened very quickly in New Zealand. And the country came on board. So we've now got a quite different youth justice system, but we still retain quite a punitive adult system. So the two sit together quite strangely. But I think most communities say there's hope for young people. We can do better, we can do things differently. This is what we did differently. Just some key features. I won't read those out, but we restricted the power of arrest. Police arrest powers for young people were restricted to the bare minimum when there was actual offending going on. Secondly, we had a real strong legislative emphasis, arguably the first in the world, that said to the police, if you arrest or apprehend a young person, don't charge unless the public interest demands it and there's no other alternative way of dealing with it. And there was virtually an overnight revolution in terms of charging. I'll just let you read those to yourselves because we're just racing through things. Who here out of interest would confess to breaking the law at least once between the age of 10 and 20? In a big way or a small way? Hands up. Judge Sinclair won't be watching. Oh, Judge Sinclair, you got your hand up. That's about right. A group like this, they say 90% will put their hands up, 10% are liars. It's part of the teenage years. We call it the whitewater rafting years, with the frontal lobe still developing. It's part of teenagers to test boundaries, to push, sometimes to make some dumb and reckless decisions. But we know with good community-based interventions, and we've got a separate specialist division of the police. We paid them more, trained them harder. They became those who worked with young people. Any young person apprehended or arrested in rare circumstances came to the youth police. They decided whether they were charged or not. And that was what happened. We don't often talk about revolutions in law, but that was a legal revolution. Overnight, the number of people in court just plummeted. Most youth courts in New Zealand now sit half a day a fortnight, but with the toughest of the tough. 80% now are dealt with community-based without charge. Judges never see them, never get to court. They don't get family group conferences. They get police-supervised, community-run diversionary programs. And about 80% of that group never offend again. That's been our big success story. But for the toughest small group, the 20%, these are the ones who come to court. So we reserve court for the real tough people, like the young man last night. And for those young people, they get the family group conference. They don't even have to admit the charge in court. They've got to say, we're not denying it. We're not actually saying we didn't do it. That's enough to trigger the family group conference. And it's at the family group conference that everything then is discussed. What happened? How can we put it right? How can we stop it happening again? Very like the circle sentencing process we heard about last night. You can have this PowerPoint at the end. The family group conference determines if the charge is admitted. Often comes up with a plan. The plan can be 3 to 12 months. I think the plan for the young boy last night's for a year. If we can't get a plan or the offending is so serious, then the court will step in and make a decision. But wherever we can, we have a plan that can be completed and a young person can earn a clean slate, a clean record for life. That's our family group conference system. Thomas will talk a lot more about that in a moment. But just in summary, a few brief comments about it. It's really a form of partial delegated decision making for all cases except murder and manslaughter. Small group, about 2,000 young people in New Zealand a year. And as we heard last night, they need to be well prepared and well run. We don't use the family group conference for that 80% who the police deal with. We would think with all the resources, time and energy that's involved, it would be overkill. And interestingly, when they were devised in New Zealand, we never knew of restorative justice. We now practice in a restorative way, but the legislation never uses that word. It wasn't in currency in the late 80s. It's not actually, I've got to say this, there's some disappointment about this, but it's not an explicit Indigenous Māori model. Much of what is done in a family group conference, as you'll hear, is consistent with the Māori model, but it is not an imported Māori model. That would be to overstate it. Even the most fractured and broken families, we can usually in New Zealand find an auntie or an uncle or a grandmother or grandfather somewhere in the country who can play a functioning and important role. And the great thing is they're not that expensive. They take a lot of time. But they harness the resources of the community. And they put decision-making back with the family and the victim. That's what happened to our custodial rates of responses. Homes and youth prisons were closed. Does it work, you might say? Well, the great majority of young offenders who don't come to court don't reoffend again. So that works, and we've unclogged the criminal justice system for young people. The 20% who do come to court, 32% don't reoffend again straight away. 20% within a year have stopped reoffending. That's about 50%, slightly more, who don't reoffend. People say, well, Judge, what sort of chocolate drinking, kumbaya singing, slap over the wrist with a wet bus ticket type of approach is that? I mean, we want real criminal justice. Well, you tell me anywhere in the world for that toughest 20% that approaches a reoffending rate of about half. No one that we know of. It's a tough group. Half is a good model. It's a good rate. We could do better for sure. The victims who come, we don't get enough victims because it's optional, but the victims who come, 89% say it was more than satisfying. So if you can get a victim there, the process has proved to be extraordinarily meaningful and satisfying. Let me conclude by telling you about a boy called Hemi. In fact, Judge Hemi Tomonu shares the name of this boy. It's not his real name. He faced a charge of what we call aggravated robbery, pretty similar to what the boy faced last night. He went with some mates with a BB gun. Do you have those, BB guns, to a corner, you call them a drugstore? He was a lookout, knew what was going on. Not much was stolen, because not much ever is when those robberies take place, but it's very frightening for the owners. As an adult, he would have gone to prison. 42 people came to the family group conference. It took 7 hours with several breaks. Quite a powerful conference. The owner of the drugstore and his wife were really strong. Now, they were right at him. You do not know what this has done to us. We don't sleep at night. It made a big impact on him. It's a big plan put in place. He had 18 months to complete it. He did pretty well. But no one knew whether he was a drug dependent, not at school, considered probably someone who wasn't going to make much of himself. No one knew he was a talented songwriter. So he said, what I want to do as a result of meeting the victim, who said after all the process, you've got to come and work for me. I've seen what has gone on. If you work with me, you can work for me for several hundred hours. I think I can help turn your life around, although I was your victim. This is the song that he composed to the owner of the shop. And I end with this. It's actually quite insightful and moving for he was 15 at the time, to write this song. It's a new vision. As he himself said, as a 15-year-old, a new era began in his life, but a new era began in 1989 in New Zealand. It was a risk for our community. It was a big risk. We sort of took a big jump. But thankfully, it's paid off. The community's been behind it. We couldn't turn back the clock now in New Zealand. We're not perfect, but we'd never go back to the bad old days. And what we need in New Zealand is that vision continually held up above, because that's what we're aiming for. And now these two colleagues of mine, the real experts, they'll tell you what goes on in more detail. Thank you very much.
Karanga wea ta whanau e, ucha te rito o te hara keke, kei hea te ko mako e koe. Haka tai rangi tia, rere ki uta, rere ki tai, naui ki mai, e aha te mea nui, maku e ki atu, he tangata, a he whānau. Te mea tutahi māku. Ko te ariki hroi nei haka nei ngā mea katoa ko i te tarotoro, hei kai matahunga mate kai, hei kaha mo te manene me ngā kaimahi. Te mea tūroa, no he te tangata tūmai mui a koutou, ko pohatu te maunga, ko te karai te aua, ko pōwhiri te whare tūpuna, ko pā te oro, te marae, ko ihu tai te hapu, ko ngā puhi, tōku iwi. Tēnei e miha tū, ki ngā tini mate maha, e pānia tātou mai te timatanga o tēnei tau, tāitu ki tēnei rā e tūnei kia rāta koe he tuki te pō, haere, haere, haere atu rā. Kia tātou te hunga ora, tēnā hūtau. E rauranga tira mā, e ngā iwi, e ngā reo, e ngā tangata whenua, ngā mihi nui. In brief, I just wanted to thank each and every one of you for allowing me to be a part of this process, being a part of this very important kaupapa. I just want to acknowledge Judge Sinclair. He said something over the last few days that I've heard and I've taken on board. I actually think that the word courageous is what he uses. And I think he took a leap of faith in relation to the pathway he wants to see for the community within Seattle or King County. So I just want to acknowledge that, because back in 1989, our government, our country, took a huge leap of faith to bring on board a cultural view in relation to how do we work with our young people. Puao Te Atatu, The New Dawn, was presented back in 1985, 1986. This document is what made the changes to our legislation. So I have to acknowledge, and this has been my mantra as a practitioner, a Māori practitioner within the government department that I work for. The Māori child young person is not to be viewed in isolation or even as a part of a nuclear family, but as a member of a wider kin group or hapu community that has traditionally exercised responsibility for the child's care and placement. The technique, in the committee's opinion, must be to reaffirm the hapu bonds and capitalise on the traditional strengths of the wider group. That is not a monocultural view, that is a communal view. And that can work across any community, any ethnicity. But you need a vision. I have to get straight into the work, so I'm here to talk about who I am and what I do. Yes, I've been practicing as what we call a family group conference coordinator for 14 years. 14 years is a long time. Long time to maintain that passion. But that mantra, what you heard me say earlier, that is what gives me passion, because I love working for my people. I love to find the pathways forward for our young people to find a better way and a different pathway from where they're headed. In my time working, I've worked right across the board. I've worked with those that have raped, those that have put people in hospital, those that have made people paraplegic, tetraplegic. I've walked into gangs' homes. I've walked into, believe it or not, rich homes. I've worked right across the board amongst many ethnicities. But that mantra is still the same for each and every one of them. I want to work with the family to ensure that the family participate in those decisions. Currently, the law that we work under, Children, Young Persons and Their Families Act, we have two ways of getting referrals for a family group conference. The first pathway is through the police. They make a referral. Now, the interesting part here is that the young person is not charged. The young person hasn't been arrested, but the police do wish to charge them, and they do wish to lay the matter before the youth court. The opportunity is the family group conference. It gives the opportunity for the family to come together to make decisions about what they need to do to address the offending and hopefully not have the matter laid before court. There is a time frame, there is a plan. But that is the key, the opportunity to say, we can deal with this, we can deal with it in our community in a way that we think is best for a young person. Yes, he does need to be accountable. Yes, he does need to make things right back to the victim. We understand that. But we want to be able to do this for our young person so that he doesn't go forward in his lifetime and carry that charge. That is an opportunity. The second referral that we get is through the courts. And very interesting, any young person that has been arrested and their matters are laid before the court, except for murder or manslaughter. So yes, as I've said, I've worked with people that have raped, I've worked with people that have, young people that have harmed a person, I've even worked with a young person who made a young woman a tetraplegic. The family group conference itself was never instituted to be a practice around, I'm trying to think the word, it's just gone out of my mind. It was never supposed to have the ideal in relation to working on a cultural process in relation to addressing, making the victim, the young person come together and looking at that restorative justice. That was never actually the original idea. That's what came out. But the opportunity was laid there, and that's what we took. The young woman that was made a tetraplegic and the young boy himself came together in a cultural process to address the restorative justice. From that process, that young boy was able to do a minimum term of 6 months with 12-month supervision after that. But the healing between the families and within the community, it stopped the ongoing fighting that could have happened. It's not about necessary forgiveness, but it's about ensuring the safety of the community and the reprisals. So there's always an opportunity to work in the favour of the family, the young person, the victim, and the community as a whole. Part of my role as a coordinator, I must consult with every person on this list. I must talk, I must tell them about what the process is, what their rights are in relation to the family group conference. The young person, their parents, the wider whānau or wider kin group, the victim, the youth aid officer or police, and of course the youth advocate or lawyer for young person. Actually in the law I don't have to, but it always pays to, because one day that lawyer could be a judge or could be the regional commissioner for New Zealand. It's happened. I've got two of them sitting over here. So as a coordinator, always pays to think strategically. So these are the key people. These are the key players to come together to make decisions for that young person. Any person that does this type of work, who go out and meet with families, know that it isn't as easy as that, because it isn't. Work is hard. Our families are hard, because you're not working with people that want to work with you. You're working with people that don't want anything to do with you. So what is the magic thing that I can tell you that you can get out there and do it? I still haven't worked it out, but persistency, persistency works. What I do know is that when I work with Māori families, I have a natural way of working with my own. I notice that other colleagues from other ethnicities, when they work with their families or their own ethnicities, they have a way of being able to get in and work a lot easier. That's what I do know. What I do know, if you're working across, get an expert from that particular group, work with them to work with that family. Whatever you do, if you're not able to get in yourself. But I do know there's some great coordinators, no matter what the ethnicity is. They have a natural, born way of working with whomever. But those people are hen's teeth. But if you're one of them, then I say, and I congratulate you, because it is not easy working across other ethnicities. Next day. Okay. So, you know who I have to talk to. Now, the conference actually has to deal with the holistic view of what's happening for that young person, and also what's happening for that family. So we need key people to attend that conference. The role of the coordinator or the person that sets up the family group conference, they need to have a certain amount of analysis to determine this is what's needed with this family. So I'll bring these people along. The family don't necessarily have to agree to what they bring, but there are options that you can bring to the family group conference. Because the only people that can say anything to a plan, agree to a plan, young person, their family, their parents, the youth aid officer, and of course the lawyer. That's education, health, community organisations, even a statutory social worker is not entitled to be at a family group conference. They can be asked to provide assistance. Anyone that may be relevant or pertinent to ensuring that we're finding the right pathway forward for this young person and his family. But remember, in working in the system, it is very easy, as we know, for people to become dependent on you. The hardest thing is to make them independent of you. And you're asking me, what is the one magic way to do that? I still haven't come up with that. But I am still working on it on a day-to-day basis, informing family, giving them all the information and telling them, this is your child, not ours. You need to take some responsibility. But if you need the help, we can provide that too. Coming to the end. I must be on time. I haven't got the tap yet. Currently in New Zealand, we've set 10 practice standards. Unfortunately, I sent the information through, but it didn't get through, but there will be copies of what each of these practice standards mean. But it's required for every family group conference that you hold. Now, in child, youth and family, we have care and protection, which is about child harm, child trauma, and then we have youth offending. And they work under the same umbrella, under the same team. Suppose a bit like your American football. You have an offensive team and you have a defensive team. Yeah, that's the closest analogy I can get to it, okay? That's it. So they're part of the one team. I've got to hurry up and... They're part of the one team, and in that one team, what they do is they do different jobs. These practice standards set the benchmarks, the ideal of how we are to work with our families and our young people and our children. So nō reira tātou mā, tēnā koutou, kia ora hui mai no tātou. Thank you very much.
Ko Hikurangi te maunga. Hikurangi is my mountain. Waiapu te awa. Waiapu is my river. Ngāti Pro te iwi. Ngāti Pro is my tribe. Nō reira tēnā koutou katoa. So greetings to everybody. One of the ideas behind coming here is to share ideas so that the ideas we're talking about might be ideas you can think about and how they're relevant to your situation. So if I give the impression that I'm telling you what to do, then you're free to ignore it, even though I'm a judge. I've got a video that I'm going to show you in this presentation. I've also got a PowerPoint. And before I show you the video, I need to give you some background as to why I'm showing you a video about the rangatahi courts and where they fit into the presentations that you've already heard. Judge Beecroft has given you a full overview of our youth justice system in New Zealand, and Thomas has told you the details about family group conferencing, which is the equivalent of the circles that you're talking about here in your area. What I'm about to talk about is the development of our youth court to specifically address Indigenous young people, Māori young people who are offending. And so that's what this video will be about. Before I show you the video, I want to just tell you a couple of things about it. You're going to see a lot of footage of actual court sittings, and they are not circles and they are not family group conferences. They are the actual court sittings, the footage you're going to see. The other point about the 1989 legislation that both Judge Beecroft and Thomas have talked about, that was a legislative development. So our government of the day put that in place. The rangatahi courts we're talking about now were a judicial initiative that was made possible by the leadership of Judge Beecroft, who was our equivalent of Judge St. Clair at the time in New Zealand, and also our Chief Judge at the time, Russell Johnson. Without their courage and vision, what I'm about to show you would not have happened. So I want to acknowledge Judge Beecroft. I also want to acknowledge Judge St. Clair because he's effectively in the same position that we were in when we talked about doing this, a judicially led initiative that requires full buy-in from all stakeholders and the community. Obviously, we have a lot of stakeholders here. So without any further ado, I think that explains the video I'm about to show you, except for the fact that once the FGC process has finished, so once the circle has come up with a plan, the rangatahi court I'm about to show you monitors the progress of the young person as that young person completes the plan. So that puts it into a little bit of context. If you've got any more questions, we can talk about it later, but that gives you a rough idea of what this is all about, what I'm showing you. Ka pai? Ka pai means good, and you say, ai. Kia ora. Kia ora means good.
If you want to reduce crime across the board, we need to have a court process that is culturally sensitive and recognises the people that come before it.
I tīmata mai e te kaupapa o te kōti rangatahi tūranganui ākiwa. I te mea, te nui ngō ngā tamariki mokopuna kei te haramai ki mō i te arororo te kōti taioi i taua wā, kaore i te mōhio o te reo, kaore hoki i mōhio ko wai rātou no hea rātou. Koira te tino kaupapa, ka noho moke moke, rātou ko rātou whānau, i te ao Māori.
The real challenge was how do we work better and provide a new model using the same legislation for our Māori rangatahi before the youth court.
The objection was, if we bring the system to the marae, we are inviting the legal system to invade the last bastion of what we call taha Māori. And the kuia who stood up turned the meeting, said to everyone there, e hikama, the kaupapa is about the rangatahi. It's not about the mana of the marae, it's about the rangatahi. Bring them into the bosom of the marae so that they can feel what these marae have to offer. They can rongo te wairu o te marae.
Pōheri actually is quite calming for a lot of young people, I think. Just from the start of the day in the pōheri, everyone is on the same level, everyone comes in the same gate, and there is, I think, a really, really good opportunity for connections to be made. Young people talk to police officers, they talk to social workers in a different way than they would if they were in a normal youth court environment.
The marae has always been a haven. The marae has always been a sanctuary. Marae has always been a place to stand and talk.
Well, Te Koti, they have a lot more support and they actually say a lot of things to you to encourage you to do better.
It made me feel like they actually wanted the best for me, and I felt like I had a lot of support. Made me feel loved. Didn't feel like I was going through this on my own.
With Te Koti Rangatahi, once we get here, we're in the wharenui, the young people get that engagement with people who they've not met before, with komata and the kuia that are present, and they actually listen.
I tell them they need to lift their eyes off the ground. You need to look out and see what's out there and then make your choices. The last time I saw this boy, I felt very proud for him because he kept looking up and he started to hold his head high.
I say to the young people when they come to court, if there's one thing you remember from your experience of the rangatahi court, I want you to take this with you for life. It is your pepeha, identity, tuakiri, and that starts with your mountain, your river, and your tribe. Ko wai koe, no hea koe, nā te aha koe.
Ko rākau tapu tōku maina, ko Whokeanga tōku moana, ko Māngari tōku waka, ko Tapuai tōku awa.
The Pacifica Youth Courts came off the back of Te Koti Rangatahi. It was always the intention that once that court was up and running for Māori young people, that we would have a similar model for Pacifica young people. It's been fascinating to see law, culture and faith in one process, and to see them leave the justice part behind and take with them the culture and faith.
I have seen some spectacular examples of successes in the Pacifica Youth Court, which I don't believe we would have achieved in the district court, youth court setting. We have to trust people that they will grow and develop, just like we as individuals think we have grown and developed. These young people are entitled to those same opportunities and have a right to expect us to go along and act ethically, professionally, with an open mind, but really importantly, I believe, with an open heart.
It's not a separate system, it's an adjusted system, part of the whole, and I would resist any suggestion that we're doing something separately. It's a culturally adapted process.
The image of the scales clearly have been unbalanced for too long. And that the Māori effort to balance the scales of justice starting to shine through.
It's always been said that Rangatahi Court is not a magic bullet, but it does what it does. It plays its part. And the most important part it plays is by transforming the face of a justice system to allow the Māori voice to be heard. It enhances respect for the rule of law when the law is speaking in the language of the people it is dealing with.
For me, working with a group of Māori judges who have become real colleagues and confidants, that's been inspiring for me. And to see their mahi, I think the country could be cautiously optimistic. And in one sense proud of what a group of committed and visionary judicial leaders have accomplished.
Now, you might have heard that I am a judge, and there's also a saying that power corrupts. PowerPoint corrupts absolutely. The only way to address the corruption in a PowerPoint is to use the fast forward button. And that's what I intend to do. So don't get worried about how many slides are on here. I'm going to give you a visual presentation, but you have to stay with me very fast. Some things I do want to emphasise before we float through some photos on this PowerPoint is that there is a lot of jurisprudence and a lot of academic writing about restorative practices, restorative justice. I want to share ideas from New Zealand, from the tribal leaders that I've listened to about these practices, to give you a cultural lens from my perspective. We talk about Sky Father, Earth Mother. We talk about the ability of Māori people to trace their descent from Sky Father and Earth Mother. And in my particular case, we come through one of the children of the parents, Tangaroa, the god of the sea, and we're a coastal tribe. We live right by the sea, as you do here. All Māori tribes can trace common descent through that same line of genealogy. So the fundamental essence of the Māori culture is based on kinship and relationships, human kinship relationships. When harm is caused by one person against another, one sub-tribe against another, one tribe against another, that human fabric of relationship has been torn, and there are processes involved to try and restore balance and bring peace. And that's a universal human idea of reconciliation. But the point is, from our perspective, it is based on that idea of we are all related through that cultural understanding of Mother Earth, Sky Father. I share that idea with you because you would need to think about how does that relate to you, because you'll all have different understandings of how we relate to each other. That is a cultural understanding from New Zealand I share with us. I talked a little bit about the prison rates. It's all very well saying half of the prisoners in New Zealand are Māori, but it's very important to understand the trend. The trend from 1890 until the present day shows, in the red line, the Māori rate of imprisonment from 1950 onwards, going in almost a straight line up. And the reason for it is that our people moved from the villages into the cities and left all of the leadership behind them and have found trouble in the cities. That's effectively one of the major causes, along with poverty. I'm sure that you share similar experiences here. These are the youth prosecution rates I wanted to talk about. That graph there shows in red the Māori percentage, the black shows the non-Māori. So that's many ethnicities living in New Zealand, represented in the black. Māori, young people aged 14 to 16 are represented by the red graph. And here are the prosecution rates. So again, we are talking about a significant problem. That is the 2015 position. So it's very recent, and it shows we haven't yet successfully addressed this issue. And I think if you think about how does that relate to you, well, you've no doubt got the same issues going on here. Now, I talked about the fast forward button. That's exactly what's happening here. Because I want to get to the point. The Rangatahi Court came out of this idea that we need to do something different. I heard Judge St. Clair talking about insanity yesterday, doing the same thing over and over and expecting different results. It takes courage to do something different. It also requires vision. And everything I've heard Judge St. Clair talk about so far is a combination of both. So I want to acknowledge Judge St. Clair for what he is encouraging everyone to do, because it doesn't just take Judge St. Clair to have courage and vision, it takes everyone. Everyone has to move forward in the same direction. And so I just make that point. That's how we moved from where we were in a conventional courtroom to what you saw on the traditional venue we call the marae. I'm sorry I didn't explain some of the terms. I was trying to do it, but it didn't quite work. There was a lot of Māori spoken in the video, and a lot of words were used in Māori that may not have been understood by everyone. The key word was rangatahi. Rangatahi means youth. My father is a cultural expert. He's an elderly man. When we first started this idea in 2008, I said to him, "What shall we call this court?" He said, "Rangatahi Court." I said, "No, that's too simple. That can't be right." Anyway, Judge Beecroft was on me for 2 years, on my back, saying, "What are we calling this court?" Because we called it all sorts of things that were, we called it all sorts of things that weren't quite relevant. We ended up with Rangatahi Court. So there's another question, there's another idea for you. If it's simple, don't just dismiss it. It might be right. Now we get to some photos. I've talked about vision. We all know that none of this happens without vision, and so I'll move on. Before I do move on, I just want to focus on that last piece there. What is the vision for Māori young people who are offending in New Zealand? This is it. This is my vision for them. I think it's a shared vision because it's hard to argue with. They are engaged. They have high expectations, and we have high expectations of them. They are confident. They are achieving their goals that they're setting for them, that we're helping them to guide down the correct path. They're contributing members of society. That's what we're trying to achieve. And in our case, they're bilingual and bicultural so that they have a sense of pride of being Māori, because many of them, although they have the same colour skin as me, do not have the same understanding of who they are and where they're from. That's why we make them learn that idea of their mountain, their tribe, and their river. And that's more about vision, which we can move on. So these are the photos. The purpose of the photos, these are all the launches of each Rangatahi Court. The purpose of the photos is to show you how many community people are actually involved in supporting these courts. So you can see there are thousands of people involved. We had the equivalent of your US President Obama attend one of these launches, our equivalent. He's probably not as high up there, but anyway. Oh, actually, he is. I'm on film. That's right. Of course he is. So it just gives you a sense of the community spirit involved behind this idea. This idea is not a new idea. It is a very old idea. It might be the modern day, but we're talking about old ideas. So we have 14 of them. 14 of these courts throughout New Zealand since 2008 until now, and we're going strong. Very quickly, evaluations. The easiest way to understand the qualitative evaluation is to look at that word map. The larger the word is, the more times it was said by people interviewed. And whānau means family. Better, good, comfortable. This is the quantitative evaluation that was done in 2015, which shows some very good results. To put that 11% result in context, and just to try and sum this all up, Judge Beecroft talked about 80% of all young people who commit offences in New Zealand never come to court. The other 20% who do come to court, of that 20%, half of them do not reoffend. Over and above that, we have 11% more. So I suspect that's, I'm not very good at maths, never was, but that sounds a bit like 61% are not reoffending when they come through our process. Food for thought. If you bring them to a youth court, the danger is you institutionalise them from day one. They are familiar with a system that no longer has any fear for them. And you lower their expectations immediately by bringing them through. Divert them. Deal with them alternatively. That 80% we're talking about are probably going to grow out of anyway. That's the research. So why bring them in the first place? To make them more chance or higher risk of coming back again. Whānau, family, that's all I've got. Kia ora.